to take a brief moment just to ask our two panelists for their key takeaways or their final thoughts. Paul, you led us off this afternoon. Perhaps you want to give us some of your key points from today.
Well, I guess one of my key points, I'm going to reiterate something from one of Mark's final slides, which is, he said, why not replacement cost damages? And from a legal standpoint, if you look at most product warranties, the warranty is either a limited warranty, which merely promises repair or replacement. So that's then reflective of the harm. The remedy should fit the warranty breach. So if you have a limited warranty that promises repair or replacement, that should be the measure of damages. And so often courts will look at 2-714 and say difference in value, the time and place of delivery, as opposed to what the value would have been had they been as warranted, et cetera, et cetera. And the thing about that's where the distinction between a limited warranty and express warranty is different. Limited warranty does not promise a defect-free vehicle. What it does is it promises repair. So repair replacement cost should be your parameter. So that's, I think, the key point. And again, I think the jurisdiction issue, the key takeaway there is that either side of the equation, you have to understand whether you're going after the defendant or you are the defendant, what are the real contacts? You have to understand the business of the defendant so you can do a proper analysis.
Thank you so much, Mark. We then turn things over to you. Perhaps you want to close us out with a few of your final thoughts today.
Sure. So I guess I thought it'd be, if you're going to, if you're on the plaintiff side, consider using a conjoint analysis and make sure that the person that you're using has the requisite expertise to do it, and make sure that they really spend the time to do it right. It can be expensive, but if you're going to go that route, it's not worth trying to do it on the cheap and compromise your results by not giving them the resources they need to do it correctly. So make sure that you ask all the right questions on going into it, and make sure that you kind of kick the tires on their analysis to make sure as well that they are not making some of these mistakes that I've talked about. If you're on the defense side, obviously look at these things, and there are many others as well that you want to discuss with your experts. But to get all of the underlying information for how the person actually did their conjoint. Don't just stop at their report, but if they perform the conjoint, get all of the questions, get how they designed it, get any pre-surveys that they've done, get the actual results that the respondents provided, because that's going to give you a wealth of information and a wealth of potential critiques, or at least areas that you should investigate for potential critiques.
And just a real brief note on Mark's point, I think that can be summed up in one way of saying, perform a Daubert analysis, not only on the other side's expert, but your expert, Daubert being right, the decision construing Rule 702. Because if the expert does not do a solid analysis, you may have very good grounds for excluding them. If your expert falls short, you may have spent a lot of money for nothing.
Yeah, you can always fix it before it's submitted, but once it's submitted, you can't fix it.